I thank you all for once again inviting me to the 22nd Biennial State Level Conference of Judicial Officers on the theme, Reimagining the Judiciary in the Era of Artificial Intelligence. I thank the KJOA and congratulate them on this Golden Jubilee year. I stand before the judicial officers of Karnataka today with immense feeling of pride. I have deep respect for the work you do every single day. You are the face of justice for thousands of litigants in the state of Karnataka. For most citizens, their interface with justice, fairness, and rule of law begins and ends in your courtrooms only. Every day you walk into your courtrooms not just with files on your dais, but responsibilities that are very heavy. You listen to stories of broken families, lost livelihoods, disputes over land, and sometimes deeply painful accounts of crime and suffering. Yet, despite the pressure, the workload, and the constraints, you continue to uphold the law with patience and commitment. The judges in India are the most overburdened judges in the world, and yet justice continues to be alive in this country. This is because of the dedication, particularly of the judges of the district judiciary. My Lord, the Chief Justice of India, I have immense pride in saying that the district judiciary in Karnataka is one of the best, and I thank you for accepting our invitation to be here today. It is in this context that I wish to say a few words about artificial intelligence, or AI, since that is the theme of this conference. But let me begin by clarifying something very important. AI is not about replacing judges, and it is certainly not about machines deciding cases. It is only a tool that can support you, reduce your burden, and make the system more efficient. But importantly, AI does not think like a human. It does not understand justice, fairness, or morality. It only processes data and gives output based on what it has seen before. Artificial intelligence at its simplest is just a tool. It is not a thinking being, it is not a judge, and it surely does not possess wisdom or values that a judge possesses. It does not replace human judgment, it is only assisting human work. The first and perhaps the most immediate area in which AI may be used is at the stage of filing and scrutiny of cases. This does not eliminate human scrutiny, but it only reduces repetitive errors and saves time at the very beginning of the process. Another area where AI can be deployed is in case listing. For example, it may reveal that certain categories of cases consistently get delayed at a particular stage. Based on this, it can suggest small but meaningful changes in scheduling of cases. In fact, I think the summer holidays must be made use of so that the cases are scheduled in such a way that the long cause list which is there before the judges in the district judiciary or before the High Court are scheduled in such a way that ultimately the judge is able to take up most of the cases, if not all. The system of giving of dates should be such that where we can take the help of AI so that the stages which are lengthy, such as cross-examination or a final argument in the district judiciary or a final argument in the High Court, they should be spread out in such a way that ultimately the case is taken up and a date is not just given. When it comes to legal research, AI can be particularly valuable. Importantly, such systems can also highlight conflicting precedents or recent position of law on the point. To be sure, it does not replace legal analysis or human oversight, but it ensures that the judge has a more comprehensive set of materials before making a decision. At a broader level, AI can support the functioning of legal aid systems too. With all of this means, in practical terms that the time and energy that judges currently spend on repetitive and time-consuming tasks could be reduced. In a system where delays and costs are a major concern, even small improvements in efficiency can make a significant difference to litigants who are waiting for years, over generations, for resolution of their disputes. At the same time, it is very important to address some pressing concerns. Titled Mercy versus Mankind, which did not exist at all. A very interesting title though, Mercy and Mankind, very relevant for the court though. In another instance, a Supreme Court judgment was relied upon which did not have the particular quotation, but the citation was correct. This makes verification indispensable, or else we would be compromising public trust in the institution. In view of the reliance being placed on AI in the course of dispensation of justice, I think the time has now come for the learned advocates who rely upon judicial precedents to also issue a certificate that the judgments relied upon are authentic and have been reported in the relevant journals. I was informed about a particular incident where one of the district judges in the city civil court had to deal with a bunch of judgments which were cited by the advocate. And the learned judge looked into those judgments and said that those judgments are not applicable to the case of the learned advocate who had cited them. When the matter went to the High Court, the first ground was that the district judge has relied upon judgments which are fake. Who has cited those judgments? Then the High Court should have asked who cited those judgments in the High Court. See, therefore, AI is good as an aid, but it cannot be misused or abused either by the bar or by the bench in arriving at a result. Equally important is the concern of privacy and data protection. Courts handle highly sensitive information, personal data, financial details, criminal records, and confidential testimonies. This raises the risk of data breaches, misuse, or unauthorized access. Strong safeguards must be in place to ensure that the dignity and privacy of litigants are not compromised in the process of digitization and automation. I'm sure my learned brother, Justice Narasimha, will give more information on this in the afternoon session. But I want to highlight a more broader philosophical concern about the human character of justice. Judicial decision-making is not merely about applying law. It involves understanding particular context, weighing competing values, and responding to the complexities of human behavior. There is a moral and empathetic dimension to judging that no machine can replicate. If technology begins to influence the process too deeply, there is a risk that justice may become overly mechanical, losing the human sensitivity that is essential to fairness. In the Indian context, we have already taken some initial steps towards digitization through initiatives like e-courts and translation tools. But there again, we have to be very careful. Translation cannot be literal. Leave granted. In the Supreme Court, we say leave granted. It's an order. It cannot be chutti swikar. Special leave petition. Khas chutti yachika. My Lord the Chief Justice, we have to be very careful in translating these words of art into other languages. However, the reality across district courts is different. Some courts have access to better infrastructure, while others continue to face basic challenges. Even fundamental judicial infrastructure such as adequate judges' chambers, proper sanitation facilities, including toilets for women, and essential spaces like infant care rooms remains inconsistent across regions and states. but I think that the Karnataka government has been quite generous in providing some kind of infrastructure for our district judiciary. At the center of this renewed system remains the judge. Let us not forget the judge, for he is in the center of the courtroom. He cannot be replaced, neither she can be replaced. The judge can only be supported. The principle that must remain absolutely unchanged in the midst of all the change is the rule of law. No matter how advanced technology becomes, the foundation of our judiciary cannot and must not shift. Rule of law is not a technical concept. It is a moral and constitutional commitment that ensures fairness, equality, and accountability. Artificial intelligence in this context must always remain on the periphery, as a tool, as an aid, as a support system, but never the core of decision making. The core must always be the human judgment, guided by legal reasoning, constitutional values, and a deep sense of justice. If at any point technology begins to replace human judgment, we risk weakening the very institution of judiciary that we are trying to strengthen. As I conclude, I want to return to what matters most, that is, judging and judges. AI must respect experience, discretion, and role of judges as guardians of justice. If judges begin to rely too much on AI, this can create a form of cognitive influence. AI poses a threat to human cognition by subtly shaping how humans process information and make decisions. It poses a threat to the cognitive autonomy of humans, and particularly judges. Therefore, the classical idea of judicial independence must evolve to include independence from undue AI influence. This means ensuring that judges have final control over reasoning, and that use of AI remains at the periphery at all times and at all stages. Judicial independence in the modern era is not just freedom from external power, but also freedom from algorithmic influence. The future of justice cannot be shaped by AI, but by judges only, supported by tools, but guided always by constitutional values, rule of law, and commitment to equity and fairness. There has been adequate increase in salaries and allowances of judges in the district judiciary, thanks to the Pay Commission recommendations being accepted by the Supreme Court and implemented by the state governments. But judges who are unable to live within their known sources of income and fall prey to greed and temptation must be weeded out of the system. I must add that judges must be free from influence from all external pressures and also from their own colleagues. Enlightened independence is when judges are independent of their colleagues. They must develop courage and independence. There cannot be any coordination in decision making. I repeat, please don't have any coordination in decision making. I do not wish to elaborate it, for you know what I am saying. A tainted decision by a judge is a black mark on the judge and on the judiciary itself. Hence, let us realize and be conscious of our duty to the litigant public and to the nation. I will also use this occasion to remind high courts that judges in the district judiciary must be protected and supported by the high courts in discharge of their duties by a fair consideration of their representations and the exercise of powers under Article 235 relating to promotions, postings, transfers, and leave. A fair, transparent, and responsive administration by high courts is essential to preserve both the independence and morale of judges at the district level. I must say that the fairness of the registry of the high courts while dealing with the district judiciary is equally important, for no judicial officer must feel that he or she has been left in the lurch only because the registry of the High Court is not taking necessary steps at an appropriate time to assuage their grievances. At the same time, there must be a consciousness regarding the increase of women in the district judiciary. Chief Justice, particularly in the Karnataka, we have sometimes more than 50% in the recruitments who are women. There must be safety, dignity, and enabling working conditions for women judges, especially in the district judiciary. Don't give itineraries, which are where they are called itinerary judges, to women judges when you can give it to men judges. This includes not just physical infrastructure, but also institutional sensitivity and protection against bias or harassment. Strengthening these aspects is integral to building a Nyayapalika that is not only efficient, but also inclusive and secure for all its members. I thank each one of you for your kind attention. Thank you and namaskar.